Yes. I think you can see from the screen that there's more attendee coming in. Good afternoon, good evening, everyone. Yeah, we are now waiting another few minutes to start our webinar on the session 5. How a dispute board works. Yeah. So I would inform that today we have the 5th sessions of the six events in this series from dispute avoidance in Asia. Yeah, I would like to ask Dr. Savano maybe to give the introduction and also to brief us on the former sessions. Yeah. So, Dr. Savano, may I ask you to take the floor?
Okay, thank you.
Yeah, please, Dr. Savano.
Yeah, but okay. Thank you very much, ladies and gentlemen, for your attendance in this series of events about the dispute avoidance and using the FIDIC condition of contract. And today we are very lucky because we have a Jeremy Glover, who is the immediate past president of Region 2 of the DRBF, Dispute Resolution Board Foundation. Jeremy is a partner at Fenwick Alliance in UK, the largest construction law firm, yeah, and he is also listed in the Who and Who Legal Construction 2022, and then also described in the Legal 500 in 2022 as having a spectacular knowledge of FIDIC. An accredited FIDIC Dispute Adjudication Board and member of Chartered Institute of Arbitration Adjudication Subcommittee. Jeremy also the co-author of Understanding the FIDIC Red and Yellow Book, a clause-by-clause commentary. This is very valuable book. I've read this one; it's very good. Yeah, and also he is and also lead editor of Building Contract Dispute Practice and Precedents. This is very good also. Inform the books, and Jeremy is a member of the board of examiners of the construction law MSc program at King College. So if you are interested on joining the construction law King College, you can contact Jeremy. Yeah, and every year King College have the summer school for FIDIC construction contract. You can join also for this year. Yeah, and again, Jeremy is a teacher on the MSc Building Information Modeling Management Program at Middlesex University, and is a member of the Chancery Lane Project Built Environment Advisory Committee. It's a very famous project. So this is Jeremy. Today will be with you for discussion about how dispute law works. Okay, thank you, Jeremy. Time is yours.
Okay, thank you very much. So I'll just share the screen now so I can put my slides up, hopefully. Right. Hopefully you can all see the slides. So that's all good. So, well, good evening. Not sure. The beeping has stopped, I think, so that's good. So good evening, and thank you very much for the invitation to talk with you today as part of the FIDIC Asia Pacific Dispute Avoidance series of webinars. So as Professor Sarwano has said, I should be looking at how dispute boards work, and that's from an international perspective. I'll probably talk for about 35 minutes, so that should give time for any questions and discussion that you may have. But perhaps by way of a small spoiler alert, dispute boards don't work that much differently internationally as they do in the regions that you're all familiar with. But the idea of adjudication, well, it's been around for a long time. In the United Kingdom, where I'm based, about some 300 years ago, Robert Hooke, who was an architect, he carried out a form of professional adjudication, where there were disputes between property owners and builders. His fee was quite modest, so that's quite similar to the fees of a dispute board today. And he did it through a site visit with references to occasional views on the properties. And of course, site visits are a key component of the dispute board process today. But I think, as you know, and one thing you will have learned from your earlier webinars on this topic, the growth of dispute boards as we know them today is much more recent. You may well be familiar with the idea that the concept of dispute boards first emerged in the tunneling industry in the United States back in the 1970s. And gradually, as people have realized that dispute boards as a concept work, and by work, I mean help parties avoid formal disputes. And as people have understood the benefit of dispute boards, so their use has expanded. FIDIC first introduced dispute boards in 1992. The ICC followed suit about 10 years later. The development banks started working with dispute boards in the 1990s. And as you may know, most of them, including the Asian Development Bank, have signed non-exclusive licenses to use the FIDIC 2017 form of contract for projects that they finance. And the 2017 FIDIC contract, of course, uses the Dispute Avoidance Adjudication Board. And other contracts have followed suit. The NEC form of contract is an engineering contract. It's very different in form. If you look at it, it's very different to the FIDIC form of contract. And it's got some international use. It's used a lot in the UK. It's mandated by the UK government for use on a lot of UK projects, including some of the big infrastructure work and some of the nuclear work that's going on in the UK. It's also used a lot in South Africa, Hong Kong, and Peru, and on various other projects dotted around the globe. But they copied FIDIC. And they introduced the Dispute Adjudication Board in 2017. And now in the UK, we're seeing the domestic contracts also looking to introduce a dispute board option. As you may know, in the UK, we have a statutory form of adjudication which allows or requires or enables parties to resolve their disputes within a very short period, 28 or 42 days. And that has been around for over 20 years. And it's one reason why dispute boards weren't used so much in the UK. But there's also been a recognition that on the big infrastructure projects, the projects that last for a number of years, there is a benefit in having a dispute board to help encourage dispute avoidance, to help the parties get along, and be able to concentrate on the job in hand, building the project. Of course, all the dispute board rules in the various contracts are slightly different, and we'll have a look at some of the differences as we go through this short talk this evening. But I was asked today to give you some examples from an international perspective. I think one important thing, one major international trend is the increased focus on dispute avoidance. And I think dispute boards play a major role in all of that. But of course, it's not that easy to find examples of dispute boards in action. In a lot of instances, there are issues in relation to confidentiality. And that's why people tend to focus on the major projects. And I am no exception. I'm going to look at some major sporting events, the Olympics, London 2012, which some 10 years ago now. They used a NEC 3 form of contract, not FIDIC. There was no dispute board, as I've said, but statutory adjudication applied. And they set up 2 panels. There was an independent dispute avoidance panel, which was the first recourse if problems arose. And the idea is that they would hold regular meetings and they would monitor the project. So that's like a standing dispute board. There were few rules. It was very flexible. It was really what worked for the parties. And I think that's quite important, because when it comes to the use of dispute boards, wherever it may be, and where it comes to dispute avoidance, what matters a lot is it's a consensual process. You need the parties to buy in and agree to what's happening. And the second panel was more to comply with the UK rules for statutory adjudication. And that was the idea of the Dispute Adjudication Board making a formal decision. Well, there was also a specialist court set up. The courts were there to be able to sit on short notice in case disputes emerged, because one of the issues in relation to the Olympics, of course, it had to start on a certain day in 2012. Well, from a London 2012 point of view, the clear conclusion was that the dispute avoidance, dispute adjudication scheme worked. And we know it worked because the specialist construction court wasn't required at all. The parties were able to resolve their differences through the mechanisms of the contract using the hybrid, using the specialist or the tailored dispute boards that had been set up. And there were 1 or 2 minor disputes that filtered through the courts after 2012, but they were very small and they certainly didn't involve the main projects. So what happened in Rio 2016? Here, there's a very clear process set up. Members were going to be chosen from a list of adjudicators. The dispute board members received specialist training from the DRBF. The members of the dispute board had to speak fluent Portuguese or Spanish. Understanding what parties say is such an important part of the dispute board process. Communication is so important. The dispute chair was also chosen from the specialist list. And the idea was that there would be regular meetings to discuss the status of the project, see what was actually going on, and assist the parties in whatever way was possible to avoid major disputes. In the usual way with the FIDIC form, fees and costs were split 50-50, and decisions would be binding unless overturned by arbitration. Now, unfortunately, to be honest, it didn't really go to plan, and the dispute boards were rarely used. There were budget cuts, which meant the idea of a standing dispute board didn't work, and so parties were encouraged to use ad hoc dispute boards as and when a dispute board arose. But the benefit of all the work and training that went into dispute boards and training potential members of dispute boards in the run-up to Rio 2016 was that parties saw that the dispute board could work because when the DB provisions were triggered, disputes were resolved as they arose. The concept of real-time dispute avoidance, real-time dispute resolution. The idea of this program, it raised the profile of dispute boards in Brazil, and it created a number of highly trained individuals who were able to encourage the use of dispute boards because they saw the benefit of the dispute boards. And as a result, dispute boards are now used quite widely within South America. In fact, they're used quite widely Brazil. In fact, they're used quite widely within South America as a whole. Moving around South America to Peru, there are Pan American Games held in Peru in 2019. Now, again, they wanted to have a standing dispute board, but there were budget cuts. There were lots of challenges with the stadium building and the project and all the other projects, infrastructure projects needed to put together the games. There was a short period of time. The design was complex. Well, that's not so unusual. And there were difficulties because of the complexity of the Peruvian procurement state law. Now, Peru was using the NEC 3 form of contracts, and they amended those contracts to include adjudication, and they used the ICC adjudication rules. The results were excellent, demonstrated how well dispute boards worked. There were 5 major projects. 4, all the disputes were resolved using the dispute board. All the decisions were accepted. They were final and binding. There was no arbitration or court processes afterwards. The dispute boards are able to help deal with the claims and discrepancies through negotiation between the parties. Because one of the advantages when you have a dispute board and the project participants trust the dispute board, well, they may come to the dispute board and ask for their opinion. They might not want there to be a formal decision. The 5th project, there weren't actually any formal referrals to the dispute board, but that was because the parties were able to avoid disputes and they were able to negotiate resolution to claims and potential difficult areas. And they were assisted in this by the dispute board. So things went well in Peru. So what about the future? Well, Los Angeles is holding the Olympics in 2028. Now, in Los Angeles, in California, they use dispute review boards on large projects. So we already know that there are going to be some major upgrade projects in relation to the transportation infrastructure within California, and they'll be using the dispute review boards. And the main difference between a dispute review board and a dispute adjudication board is that the dispute review board makes recommendations. It gives informal opinions, and these are not binding. They're not binding in the way that a dispute adjudication board decision is binding on the parties unless or until it's overturned by agreement, arbitration, or litigation. So you get a dispute adjudication board, which issues the temporarily binding decision. But here in California, they're well used to using dispute review boards on their projects. And the California Department of Transport, Caltrans, has been using dispute review boards since 1994. So that's almost 30 years. And you can see just how successful they are. Of the 1,200 and so projects, only about a third, 37%, they actually brought issues to the dispute review board for recommendations. The remaining projects where there were issues, they were resolved in the dispute avoidance phase. So there's a demonstration there that dispute review boards, first of all, they're helping the parties avoid disputes because the parties aren't actually asking the dispute review board to make a recommendation. And then when the dispute board review board does make a recommendation, my understanding is that they are very successful in avoiding a formal dispute, in that the parties accept the recommendation. Now, of course, dispute boards are used across the board in relation to construction projects. To take a completely different example, albeit saying it's another very, very big project, in Chern, the Large Hadron Collider project, the big research project that's taking place, is a good example, another good example of how dispute boards are being used successfully. Now, this is a seriously big engineering project. It brings with it a lot of potential difficulties. There's a lot of tunneling. The project is underground. You can see from the picture, hopefully, most of it's underground. You can't see very much above ground. So there's lots of tunneling, lots of scope for difficulties in relation to the tunneling, the conditions of the rock underground. They're using the state-of-the-art technology for all the research that's going on. From a fundamental legal point of view, they're using, there's two different jurisdictions. The project is in both Switzerland and in France. There's two separate legal jurisdictions. And there have been two projects. There's the Large Hadron Collider project, which is the first project, and that's finished. And they set up a panel of 5 members. And again, it's not that unusual on the very big projects to have a panel, because as you'll have learnt in the early parts of the webinar, parts 1 to 4, selecting the right dispute board is of crucial importance. Now, the larger projects, they last many years. They're very expensive, very, very high value. They have the advantage, perhaps, of being able to set up a panel. And they've got engineers. They've got an expert in contract interpretation. On the Hadron Collider project, person was not a lawyer. And so they had this panel to ensure that the right people with the right skills were able to deal with any dispute board referrals that there might be. And on the first project, there were 8 dispute board referrals. The decisions were accepted in each case. Dispute board was a success. None of the issues were referred to arbitration. The second project at Kern, the High Luminosity Cavern project, that's coming to an end. Again, they've got 5 adjudicators. There's a chair. This time there are 2 lawyers. There's an architect and 2 people with an engineering background. They've also got reserves, just in case. Always an interesting dilemma when there is a very long project. What happens if a dispute board member grows old? Well, here they were able to allow for that by the setting up of the reserves. Now here, they've been more successful than the previous projects. As I understand it, there may have been dispute avoidance going on. There are regular site visits. The panel are able to meet the parties and discuss issues. And I don't think as yet there have been any referrals to the dispute board. So that's another example of a successful project. They've had to adapt to the circumstances of the particular project. And I think that's always important, but they've been careful to choose the adjudicators with the right skill sets that apply to the project in question. And they've been a sitting dispute board. As I've said, there have been regular site visits, whether it's physically on site or whether it's virtual through the use of Zoom and whatever. And the dispute panels there have been able to practice dispute avoidance. And that's what dispute boards are all about in 2023. The idea is they help parties avoid formal proceedings. You don't want to be involved in an arbitration that goes on for 3 or 4 years after the project has been completed. The contractor wants to go on and build other projects. The employer wants to run the particular project. But what do I mean by dispute avoidance? And I appreciate that this might mean an element of revision, but dispute avoidance is just as important to dispute boards internationally as it is to those in Southeast Asia. The dispute avoidance can start on a project at any time. And I know there's a lot of information on these slides, and I believe the slides will be available to be shared after the event. But dispute avoidance, the idea of early warning. The NEC form of contract requires the contractor and the project manager to give an early warning by notifying as soon as you become aware of a matter which could increase the price, delay completion, impair the performance of the works. And I mean, through the work I do with the Chancery Lane project, there's the NEC4 has an optional clause on climate change. Again, is specifically dealing with early warning about matters that might adversely affect the achievement of the climate change requirements. Now, this early warning is an example of FIDIC copying from the NEC form of contract. I mean, and that's what contract providers should do. If they see a good clause in another form of contract, well, adopt it, make it fit your own. But dispute avoidance, it can be a difficult concept if it's something you're not used to. The idea of the early warning, putting your hand up and saying, we think there's a problem. But it's clearly a good thing, because if you are alive to there being a problem at an early stage, then potentially it can be dealt with while it's still small, and it can be easily resolved through discussion or whatever amongst the parties. And sometimes the dispute board can be a part of that. If you have a standing dispute board, they're going to be interested in what early warning or advanced warning notices are being given, because there's an opportunity to nip disputes in the bud, to resolve issues before they become disputes. And that's what a dispute board in 2023 should be all about. But of course, you know about the types of the dispute board. I've talked about the dispute review board. We gave the example of how it's working successfully in California. FIDIC used the dispute avoidance adjudication board, the 2017 form of contract. It's there deliberately. The word avoidance is there in the name, because that's what FIDIC want to encourage the parties to be doing. You can combine everything together, have a combined dispute board. There are lots of different ways of operating the dispute board process. The idea of a conflict avoidance panel, effectively, it's doing a similar role to that of a dispute board. And so the concept of the dispute board internationally across the globe, dispute avoidance. And you do need, ideally, a standing dispute board here. During periodic meetings, the dispute board can review the status of outstanding issues. Parties can seek opinions from the dispute board. They can seek a recommendation. This is non-binding. It's got to be a consensual process. Both parties have got to agree that the informal opinion is being issued. When it comes to dispute resolution, it's the resolution of claims. It's the issuing of a dispute. But both dispute avoidance and dispute resolution, the idea is that happens in real time. The idea is that parties look to a dispute board to see if they can help assist in the resolution of issues, sort it out there and then when the disputes arise, rather than storing up the disputes till the end of the project. And just looking, I mentioned the UK domestic form, the JCT form of contract. This is how they deal with the idea of an advisory opinion, the idea of a recommendation. The dispute board can provide the requested advisory opinion. So the dispute board has got to be asked for the opinion by the parties. It can be during a conversation with the parties. It can be during a meeting or a site visit. It can be in the idea of a written note. And the idea here is flexibility. what suits the parties. So if you are a dispute board member, again, this shows the importance of selecting the right people to be your dispute adjudication board. They need to have the flexibility to move quickly. They need to be experts in the construction process so they understand things, so they can give advice in meetings. They can look at clauses of the contracts. They can look, equally importantly, they can be shown what's actually physically happening during the construction process, and then they can provide the advice. So with the JCT rules, the parties are not bound to act upon the advice given during the informal assistance process. So this is part of the idea of the recommendation. More formally, the NEC form of contract, this is the NEC 4, and they've set up the Dispute Avoidance Board. It's a standing board which is appointed at the start of the project. The contract clearly says the DB is there to assist the parties resolve potential disputes. So you're not waiting for there to be a formal dispute. If the dispute board is aware of potential issues, and the dispute board may be aware of potential issues because they visit the site, they review potential disputes and help the parties settle them without the need for a formal referral. Now that's dispute avoidance. They're trying to work with the parties to avoid the dispute board having to make a recommendation. But it's there if needed. The Dispute Avoidance Board will provide a recommendation for resolving the outstanding dispute. Now that's a recommendation. The parties aren't bound to follow it. But that's the process, and that's how the NEC option works. I'm sure you're all familiar with the concept of how the FIDIC 2017 Dispute Avoidance Adjudication Board work, but it's a very similar approach to that of the NEC form of contract. You've got this standing dispute board appointed at the start of the contract. They make regular site visits. There's provision in FIDIC 2017 for there to be an informal opinion. There was provision in the FIDIC 1999 form of contract for there to be an informal opinion. Excuse me. But parties didn't take it up, and some parties weren't so aware of it. And then FIDIC, of course, has the formal 84-day process. Now, this is where I think there is a difference internationally in the way in which dispute boards do operate. Are you going to go down the recommendation or the informal opinion option, or are you going to rely upon a decision? Now, which is best? The slightly unhelpful answer is it depends. And it's always bad when a lawyer says it depends, because you want people to be actually giving you an opinion, what they actually think. But it really does depend, I think, because it depends on the process. It depends on the project. It depends on the parties. Now, what is important is the parties must agree on the process. What do they want? And you see towards the bottom of the slide, some parties want anything but a formal decision. The idea of there being a formal decision, even if it is only binding on a temporary basis, can cause difficulties internally within some organisations, because what do? And so they don't actually want there to be a formal decision, but they also want guidance. They want an understanding of what's likely to happen if the dispute becomes more formal. Now, some parties actually need a formal decision, particularly government bodies, local government bodies. they need the comfort of there being a formal decision by a recognized body, which can actually be used to, particularly if there's a requirement to make a payment, they need that formal decision before they can actually make a payment. Now, of course, as we're aware, some government bodies need actually a formal arbitration or court decision before they're able to make that choice. But as people understand more about the dispute board, the idea of a dispute board decision, it becomes much more formal. Sometimes it's a question of speed. I've spoken about the idea of a recommendation or an informal decision. It could be given at a meeting, at a site visit, during a conversation, the JCT rules actually said. Now, this is why you need parties to agree the process, because under FIDIC, the decision is made, a formal decision comes after an 84-day process. And many people think that's very quick. It's certainly very quick compared with a 2-year, 3-year arbitration. It's quite pedestrian or slow compared with the 28-day UK adjudication process, but it's still quick. But parties get the opportunity to make formal submissions. And so they get an idea, they put before the adjudication board what their position is. Sometimes when it comes to an informal opinion, you're asking the dispute board to make a decision that day. You might have had a site visit and there's been a discussion about what a particular part of the contract means. There may have been a discussion about whether some information on a drawing has actually been transferred into the construction process. And there's not going to be that much time to put that much information before the people you're asking the informal opinion from. You might show them the extracts from the contract. You might show them and you might have a discussion about what the clause means. You might show them the particular drawing revision, and then you all go and have a look on site. So often the clue's in the name, the informal decision. It's informal. There's less time to explain things in detail. But sometimes that's not necessary. So this is why I say it depends. The beauty of the FIDIC approach, with having the informal opinion option and the dispute decision option, is you get the best of both worlds. When it works for the parties, if they trust the dispute board, they can ask the dispute board to give their view, to give an informal opinion on a particular issue. But they know also that the option is there for a more formal process, which takes a little bit longer and gives the parties the opportunity to consider some of the issues in more detail. So it does depend. It depends on what's right for you and what's right for your project, depending on who the parties are. And I think internationally, you'll see that there's going to be differences in approaches. I've done a lot of work in Eastern Europe, and that's one of the areas where traditionally the local authorities are looking for decisions from arbitrators or decisions from the courts. Well, to some degree, that changes in that you learn and you hear about authorities accepting decisions. But towards the end of last year, the DRBF held a conference in Cairo in Egypt, and there was discussion about the idea of recommendations or decisions, and the view of the people who worked in Egypt was that they could see that employers and contractors might prefer the recommendation route because they were getting an opinion from respected people, but it then gave them scope to see whether they could resolve the issues themselves. So it's something you need to think about. And as I say, the advantage of the FIDIC form is it gives you the best of both opportunities. And I did just want briefly to just touch on site meetings. I've spoken a lot about the importance of site meetings and the fact it's a good opportunity for the dispute board to meet the parties. You've got to think about how these meetings are going to take place. There's the boring legal bit that you've got to check that the contract actually gives the parties the right to hold site meetings, particularly when they become hearings virtually. Most rules do. But think about how often you have the virtual site meetings. Now, I've talked a lot about dispute avoidance, and one of the best ways to avoid disputes is communication, talking to one another. Now, I know because of COVID and everything, there was a time where we could only operate through Zoom, we could only operate over the video. And that worked well, and it worked surprisingly well, and it worked much better than I thought anyone would have thought if you'd asked them before the event. But I think, and I also recognize that a good advantage of the virtual approach is that it can be cheaper. It's more cost effective, it's more proportionate, and it enables more people to take part in a process. If you have a site meeting on site, people have to travel to that meeting. If you have it virtually, it's a lot easier for people to log on. But what you miss is the face-to-face communication, the face-to-face talking. And one of the advantages of the standing dispute board, one of the great things for a standing dispute board, is the ability to develop a rapport, to understand, get on with, to know the people who actually work on the site. So I think, like all these things, there needs to be a balance. Yes, used virtual from time to time because it's got a lot of advantages, but don't always substitute it for this idea of a standing board, actually face-to-face contact. It's a balance. I think you need to do both. And again, it's an advantage. It depends on what's best for you and what's best for your project. So why do we use dispute boards? Why are we talking about dispute boards? Well, the contract says you have to. You don't have a choice. If contract says it's there, do it. You never know. It might be to your benefit. Often, decisions of the dispute board are actually a precondition to arbitration or litigation. So you have to go through the process. But of course, the best reason is they might work. They're there and, you give it a try. You don't want to end up in arbitration. I mean, people don't always use dispute boards, and of course, that's right. I think what we're seeing is more people are using dispute boards now. They're beginning to see the benefits of them. FIDIC have always said, this is going back quite a long time now, 2008, prevention is better than cure. The dispute board is entrusted with the role of providing informal assistance to try and resolve disagreements. And I think FIDIC has demonstrated since 2008 that dispute boards can do this. The UK courts have acknowledged that this is a dispute review board as it happens. They're becoming more common. They keep a weather eye on the project as it goes along. And they look at disputes as they emerge with the idea of nipping the disputes in the bud, preventing the disputes becoming actually full-blown arbitration or litigation. So the UK courts, the judges there are recognising the value of dispute boards. But just on that point about, well, you have to use them. NEC, no dispute can be referred to a court or tribunal till it's been referred, and that includes recommendations. FIDIC, no decision can be given to a tribunal unless the notice of dissatisfaction has been given. Now, sometimes legislation encourages the use of dispute boards. Now, I know many of you are going to be experts in the idea of the Indonesian law and the use of dispute boards here. So I'm not going to say any more, but here's a good example of the use of dispute boards being encouraged by legislation. And funders too. the development banks are increasingly encouraging and mandating the use of the dispute boards. But more than that, they're looking into how the dispute board works, trying to make the dispute board work. And one of the particular issues that sometimes stand in the way of the use of dispute boards is cost. Who's going to pay the dispute board? It should be split 50-50. Where are the funds for the dispute board going to come from? JICA is one of the, gives a great example. They provide for the funding of the dispute boards within the loan. And that's something that I think other development banks could and should be doing as well. So do dispute boards work? Well, hopefully over the past 20, 25 minutes or so, I've been able to give you some examples of how the dispute boards actually work, the examples from London and Churn demonstrating that the dispute boards work very well. But a really good example of how well dispute boards work is from Peru. The success of the use of the dispute boards in the Pan-American Games was such that there's now been a change in the state procurement law, making use of dispute boards mandatory for resolving disputes in all public construction projects costing over $5 million. So they saw that dispute boards worked, and the government has mandated the use of dispute boards. So that's a great example to demonstrate that dispute boards do work. And finally, the DRBF, the Dispute Board Resolution Foundation, they've carried out some research. Again, it's not easy because of the potentially confidential nature of projects. And they looked at a sample size of 231 boards. That's a project value of getting on for $3 billion US. The projects were reasonably well scattered around. A lot of them were in Eastern Europe. A lot of them were in Europe. So the sample size, you've got 231 boards. On just over half, 57%, there was dispute avoidance was being practiced. Were the parties satisfied? Yes, where dispute avoidance was being practiced by the boards, they were much more satisfied. There's 95%. Parties tended to be more satisfied in Asia, Africa, the Americas, and Australia, New Zealand than they did in Europe. The reason for that is parties were very dissatisfied in Romania. Romania is a little bit of an outlier. It's one of the exceptions, perhaps, that proves the rule that it works everywhere else. But there are a lot of the use of dispute boards in Romania is a troubled one. But they seem to be coming round to recognising the benefits of dispute boards again as they are moving forward. But what this research from the DRBF showed was that 60% of the projects with a dispute board had no disputes. The dispute boards were successfully practicing dispute avoidance, or the parties were aware that there was a dispute board and they didn't want to refer a dispute to the dispute board, so they sorted things out themselves. There were 512 decisions, 32 only were referred to arbitration, and of those, only 7 were overturned by the arbitration process. So the vast majority of the dispute board decisions were accepted by the parties, or were used by the parties as a mechanism to help sort out the differences amicably. About 18 months ago, I was involved in a project in North Africa, and there'd been 3 dispute board decisions, and there was a 4th issue about to go to a referral, and the contractor was talking about going to arbitration, and the parties were able to use the decisions that have been given by the dispute boards to put in a final settlement which covered not only the 3 issues the dispute board had resolved, but 5 or 6 other issues one of which I wasn't even aware until it was part of the settlement agreement, were alive between the parties. So they may benefit of the dispute board decision. But most importantly, the dispute board had a success rate of 94% in avoiding moving to arbitration. So I think that's quite good evidence that dispute boards do actually work. So that's probably quite a good place for me to stop. But I believe there may be some questions. I've seen there's one or two appear in the chat and the Q&A, although I haven't actually looked at them as yet. So I don't know what we'd like to do. Shall I just look at the questions, or does anyone else want to come in and comment?
May I ask Dr. Sabono to say something before we go to the Q&A session?
Yes. Ladies and gentlemen, this is a very good chance to have Jeremy here, because he works also in Asia Pacific.
Yeah.
So he understands about the habits and the customs of the Asian. So I think I will encourage you, gentlemen, to give questions to Jeremy. I think he can give you a satisfactory answer. Please.
Yeah. Okay, thanks. Well, I think, Jeremy, you see the question, right?
Yes. Okay.
And the question, the first one maybe not related to directly to you, but may I take that question?
Yes, please.
Well, the question is, can we ask for a slide for reference? I mean, can we share Jeremy's rights? I not yet consult with the Dr. Sabono about this, but in my opinion, I would like to, not ready to share the slide yet, but because my intention is that we like to, make DAB all the talks in the series as the asset of the FIDIC Asia Pacific. And I would like to create value from that, which means I would like to make a rerun on that. But in this time, I would say that those who come and would like to see all the talks has to contribute some, payment or money for us. I think that's why I'm sorry that we will not yet conclude that, but it will be a good things that if we want to make it happen, I mean, DAB, we have to create value on that first. That's my idea. So okay, we go to the second question. Jeremy, you can read, right? From
yes. So
can you go ahead with that, okay, please?
Yeah, no problem. How do you decide what type of dispute board will be selected for the project? I mean, that is a good question. It's the $1 million question, of course. I think the best route is always to go for something like the FIDIC route, which gives you both options, because most people don't know at the beginning of a project what the right answer to that question is going to be for them. And if you adopt the FIDIC process, you've got both opportunities. You can go for the idea of the informal opinion or recommendation, and you can go for the idea of the dispute board. So that's as a general rule. As the more specific rule, if parties are familiar with one of the processes and it's worked for them, or sometimes parties have worked together before and they see that it works for them, then why not go for that? So there's quite a general comment, but I'm taken with the idea that the Californians like the Recommendation and Dispute Review Board, and that's worked for them for the past 25 years. So that's what they do. I think familiarity is the most important thing. So it's if you're familiar with one option, then go for that. If parties are not, then I think it's best to keep your options open, because you never know what the best way to resolve a potential problem is going to be.
Okay.
The second question, what size of project should use 5 dispute board members? Yes, that's a good question. The churn project is billions and billions of dollars. It's lasting 5, 6, 7 years. So it's a major mega project. And the idea, I don't think I should have been slightly clearer. The idea is they have a panel of 5, and if a dispute emerges, then the chair will select either 1 or 3 members to act as the dispute board for the particular dispute. So a referral would be decided by 3 of the 5 members, or exceptionally by 1 of the 5 members. But the use of a panel of 5 or 6 is quite rare. Sometimes it's not necessarily value. It might be a project, because working on a project, again, as it happens in Africa, and it's an infrastructure project to do with a drilling complex. And there's about 19 separate FIDIC construction contracts which make up part of the overall project. And I think the idea there is that it's actually cheaper to have a small panel of 5 potential dispute board members who become familiar with the overall project. They can be selected if and when a dispute arises. So rather than having 19 dispute boards, separate dispute boards, they've got 5 panel members who can potentially sit on the dispute board. So that's a different way of doing it. It's much smaller than churn, because it's got a number of projects. So they've looked for a more proportionate way to establish the dispute board.
Mm-hmm. Okay, thank you. We still have time. Okay, there are questions coming.
Okay.
Okay.
And I'll quickly write. So notice of I can't say that word, has been given under subclause 21.4. Both parties attempt to settle a dispute. Right. What should we do if 28 days after the notice of dissatisfaction was given, the dissatisfied party reluctantly starts the arbitration process? There's not a lot you can do, because the amicable settlement period, it's there to give the parties the opportunity to try and resolve the dispute amicably. It's there to try and call the parties if they're aggrieved. But once one of the parties has started the arbitration process, you are bound by the arbitration process. You're quite right. The questioner is quite right. There's no specific limitation about when the arbitration should be started, but there's nothing to stop the party legally starting the arbitration on day 29. There's nothing to stop you as another party looking for ways to resolve the dispute outside the arbitration process. But I'm afraid my reading of the contract is you can't stop the arbitration from that process being actually started on day 29.
Mm-hmm. Right. So we have time left. Can I ask you by verbal now? If there's no DAB clause or clauses in the contract, or in the particular in the government project, what should we do? If the contractors, if the consultant, engineers would like to, have their dispute happens, what should we do about it?
Well, one thing you must always do is clearly follow what your contract says. If there are deadlines in the contract that must be met, if an engineer makes a decision or something else happens, you must always follow them, regardless of what else you do. It's very easy for a party to look to try and do something different outside the confines of the contract, only to come back later to find that they've missed a date or they've missed a deadline and they can't do something. So always be guided by what your contract says, and don't forget about what your contract says. Be bold is the answer. Suggest something. Don't necessarily suggest a formal dispute board process, but perhaps suggest the introduction of an individual to act as a facilitator, to act as a conciliator, to look to see if there is a way of resolving the issues that have emerged between you without going down a formal dispute resolution process.
Okay.
And if the parties that sort of works, then you might be able to agree an alternative process, an adjudication process or something similar. But someone has to take the first step.
Yeah, thanks. So you have 2 more questions in the Q&A box,
okay.
Please.
Yes. How does it work in NEC4? Basically the same idea. Except I think NEC4, you sometimes have to go to arbitration more quickly, and there's not under FIDIC, there's no specific limitation when the arbitration should be started. Often under the NEC form there can be, and so you have to move more quickly, which arguably isn't very helpful. But check what your contract says. And the other thing is, people always amend contracts. It's very rare that you see a NEC4 or a FIDIC form of contract which is unamended, and that's just the type of detail that people will try and amend. People like playing with the dispute resolution and dispute avoidance clauses, so always check what your specific contract says. So I said JACA will fund the employer's share of the DIB cost. What I meant by that is that there would be a part of the loan funds which would be set aside for the dispute board.
Yes.
That's the way that JICA operates. So they lend you $100 million and $500,000 are there for the use of the dispute board. That because sometimes, particularly employers, I'm afraid, will say, well, we haven't got the funding to pay our share of the dispute board. JICA will say, well, look, we've given you funding, and specifically part of it is there for the use of the dispute board. And it's a fair enough point. I mean, I suppose if funders are encouraging the use of the dispute board, then make provision within the loan.
Yeah. There's Seb, the last question coming in. Oh, thank you. Another question. Okay.
The best type of question.
So, Jeremy, if I may ask you a very, broad question, but it relates to your long experience in dispute board. What would be the starting point to apply DAB in our Asia Pacific region? Based on your, our region well, and you know that we are very, very new and in the early stage of this. What would be your recommendation of this?
How to encourage the use of dispute boards. I think it's important that people who are potential members of dispute boards are people who have experience working within the region and working on projects where the parties are. Contractors come from all over the globe, so having a familiarity with the potential parties to a contract, and I think that's an important thing, and that's an important regional thing, because everyone does things slightly differently. So I think that's an important understanding. It's equally important. This goes for wherever you are. People need to understand the contracts. absolutely fundamental. I think. I mean, they are the sort of the most important things. I think it's important early on in a project to make sure that the dispute board comes along and meets the parties, so they get to know who the parties are. I think that's quite an important thing. Quite often there's something, I know sometimes there's a reluctance to engage with a dispute board. If a dispute board can be brought on at an early stage, it gives the parties an opportunity to see who the individuals are and potentially to understand some of the benefits that a dispute board can bring.
So it's a long way for us.
Yeah. Well, no, I mean, I know, but I mean, you do have a number of talented individuals within the Southeast Asia region who can act as dispute board members, and without wanting to deny my own opportunities. I mean, this is quite important. It's something that FIDIC have been trying to address recently, is to try and ensure that there's a wide geographical spread of potential dispute board members, because they recognise that, for some people, Southeast Asia is a long way away. And you have to factor all the benefits in for dispute board members. I think it's important that dispute board members are a diverse group. So you may have one or two people from Southeast Asia. You may have someone from outside Southeast Asia. You never want 3 lawyers. But equally, you probably never want 3 engineers. You need a mix of disciplines, a mix of people. Diversity is good across the board. So you need to be looking for that. But you certainly don't need to have sort of 3 UK lawyers on a dispute board anywhere, not least Southeast Asia. You want a mix of people, mix of skills.
Thanks a lot. Yeah, please, Dr. Marai, please. We are running out of time.
Gentlemen, and we have a problem with video of Dr. Sawano. I may ask Dr. Sawano just to speak with us. We may without the video, because we cannot solve the problem of video. So please, Dr. Sawano.
To end the webinar, right?
No. Just maybe he would say something, please, because he have the problem with the video, his video.
Right.
Yeah.
Okay. Just only short, thank you to Jeremy for the joining this event, and thank you to Widun and Malay for giving facilitation on this. We still have another one, gentlemen, ladies and gentlemen.
Yeah,
we still
That's
have,
right.
Yeah, and that's why we use dispute board. Yeah.
Yes.
We will also invite another gentleman, another ladies to speak.
Yes. I feel sorry for those who missed this edition. I mean, episode of our series of talks of the dispute board. And as I mentioned, that it's very valuable. If we combine all those 6 episodes, and it would be like my last question to Jeremy, that it would be in my opinion, that we have to make all stakeholders in the construction industry understand more about this, and without giving them the knowledge or the benefits of the dispute board, I think things will not be realized in the future. So I hope that thanks to Jeremy for your contribution and sharing your knowledge to us, and Dr. Sawano, that also that you promised to invite more speakers to us for the next time. So I would like to say to the audience that though that you missed the previous one, but don't miss the last one, the sixth series, the 6th talk. When it will be, Dr. Malay?
Moment. This month, maybe it's in the next 2 weeks. I I cannot see from this screen. Yeah.
Okay.
Moment.
Okay. But don't miss that. Make sure that you register. Thank
Yeah,
you.
anyone here will get the the invitation for the last session, and also you get a reminder according to the system. Yeah, at least 2 or 3 times. Yeah, one day before and 1 hour before the start of the session of the last one.
Yeah. Times is over. So we have to thank Jeremy Grover for pleased to have you with us. Thank you, Jeremy.
Thank you very much.
Well, thank you very much for the kind invitation. It's always good. So thank you very much indeed. Cheers.
And
Take care, everyone. Thank you. Bye-bye.
Goodbye to everyone. Bye-bye.
Yeah,
Bye for now.
bye-bye. See you next one.
Thank you.
สวัสดีค่ะ
สวัสดีครับ